At a joint press briefing held on Tuesday, the Department of State Service and the police, the Attorney General of the Federation and Minister of Justice Abubakar Malami disclosed that international collaborative efforts with security agencies had led to the rearrest and extradition of Nnamdi Kanu to Nigeria. The self-acclaimed leader of the proscribed Indigenous People of Biafra, IPOB, was brought back to face trial after jumping bail and fleeing the country in September 2017. Kanu is facing various charges bordering on treasonable, felony, terrorism, and heading an outlawed society, amongst others. He was first arrested in October 2015 by the federal government, but granted bail in April 2017, following his extradition and re-arraignment at an Abuja High Court for the resumption of his trial. Many groups and the British High Commission in Nigeria have cautioned the federal government to ensure that Kanu's rights are respected and his prosecution adheres to due process. To discuss the legal and diplomatic fire was expected to ensue after his arrest and extradition and rearrangement, we're now being joined by Senior Advocate of Nigeria, Mr. Owonikoko. Welcome to the program once again, Mr. Owonikoko. I mean, make sense of this bottlenecks around it, as at now we don't even know all of the circumstances he was arrested in the first place. We've heard a lot of countries, I'm sure probably some theory will come out and say maybe Nnamdi Kanu was picked up in mass or something, because lots of countries have been mentioned. But one thing is on ground, his trial will start on the 27th of July. What are we to expect?
Good morning.
Morning, sir.
Mr. Rufai. It's a pleasure to join you this morning on Arise TV. The extradition of Mr. Kanu back to Nigeria to resume his trial ordinarily should be an unremarkable event, in the sense that once you have been arraigned in court and your trial has commenced, you are in the custody of the court. If you are granted bail, it is at the discretion of the court. It's a special dispensation, especially when the offenses for which you are being tried are not such that ordinarily enjoy bail as of right. Mr. Kanu is charged with offenses that carry life imprisonment. They are the closest you can get to capital offenses. Terrorism, for instance, is a capital offense. It's not a capital offense, but it's a life imprisonment offense. Treasonable felony as well is an offense that carries life imprisonment. So when the court exercises its discretion, extraordinarily granting you reprieve to enjoy temporary freedom pending when the outcome of the trial is determined, it is expected that every citizen will obey and give respect to due process that they themselves desire to get when they have their day in court. It's unfortunate that after Mr. Kanu was granted bail, in what ordinarily would be very, very unusual for the kind of offenses he was standing trial, and exposing people that stood shorty for him on the faith that he will be in court to answer to the case, the state has to go through this long process of repatriating him back to Nigeria, because he became a fugitive from the law the moment he departed Nigeria without leave. We have seen people standing trial for serious offenses in Nigeria, and if they had occasion or cause, justifiable cause to travel out, they usually apply to the court that granted them bail, and they are accorded special permit to go on terms, and then they return. That would have been the best approach for Mr. Kanu to have adopted. If he needed to travel, even if it was, as I read, that he was afraid for his safety, he will have had to apply to that court for special protection. So that didn't happen, I think, was an unfortunate angle to his own strategy for answering to the charges. That said, I think there's a parallel here which makes one to be a bit happy about how government went about repatriating, extraditing Mr. Kanu back to Nigeria. If you remember, in 1984, there was a botched attempt to extradite Alhaji Umaru Dikko that exercise was done in breach of diplomatic rules and protocols, and also violation of sovereignty of the United Kingdom, where, as at that time, Alhaji Umar Diko was taking sojourn. At the end of the day, the operation did not succeed because Nigerian government then engaged some, if I recall well, some private security network from Israel to assist with creating Alhaji Umar Diko and air freighting him like a cargo to Nigeria. But along the line, that exercise was botched. This time around, a lot of things have happened in the international scene in terms of crime management, monitoring, tracking of criminals, or absconding suspects for offenses. It appears from what we can see so far that the government went about this in a very professional way. And that's why it's been difficult to identify what specific, maybe international law or convention has been breached by what has happened. First is that Nigerian government cannot extradite a fleeing fugitive to Nigeria. They will need assistance of a foreign authority where the fugitive is located. So if it was the case that Mr. Kanu was extradited to Nigeria, it has to have been with cooperation not only of international police, Interpol, but also of the country of domicile where he was repatriated from. It's only upon crossing the Nigerian border into our territory that Nigerian government takes custody of the fugitive. So if there is going to be any blame about how Mr. Kanu got to Nigeria now, it's not going to be properly placed if we hold Nigerian government accountable for that. That's number one. Number two also is that presently, unlike in 1984, where every citizen has one single nationality as a Nigerian, since the 90s, when we introduced dual citizenship, you can carry the nationality of two countries. I understand Mr. Kanu is both a Briton and a Nigerian. But if he was not extradited from Britain, I do not think Nigerian government will have much to answer for how Mr. Kanu got back to Nigeria. British government may have issue with the country that assisted Nigeria to repatriate their citizens to Nigeria. That's on the assumption that the the extradition itself did not meet international criteria. I'll give you the example of the late Mr. Kashamu. For almost 20 years, there was an attempt by American government to extradite him to the US. And at every point in time, it was thwarted because the procedure for legal extradition is very technical and complex. And if you did not cross all the T's and dot the I's, the chances are the home country from where you are to be extradited, if they have a functioning rule of law, may, one way or the other through the judicial process, prevent that from happening. So that's the upshot of what has happened. I don't want to go for now into the politics of whether trial of Mr. Kanu itself is justified, because that would be prejudicing the case in court, or whether there's a selective picking on who to undergo to charge for some of these very worrisome criminalities going on in the countries now that threaten the sovereignty and peace and security of the country.
Owonikoko is here. I get the point you have made about the rights of Nigeria and about how Nigeria has gone about it. But there are some, persons, including IPOB, including Kingsley Kanu, the brother of the re-arrested Nnamdi Kanu, who are arguing that this is not a case of extradition, but rather it's a case of an extrajudicial rendition, extraordinary rendition. And that is why the Attorney General of the Federation himself, Malami SAN, has not used the phrase extradition. He talked about interception. He talked about re-arrest. Do you think that the Nigerian government has done a good thing, a necessary thing, in an extrajudicial manner, within the purview of international law?
Now, let's get one thing clear. Mr. Kanu was standing trial already in Nigeria. He was granted bail by a competent court of law. He jumped bail and became a fleeing refugee regardless of wherever he was. Nigerian government sovereignty does not extend beyond our borders. So if with the cooperation of Interpol, to which Nigeria is signatory, and other countries are also signatories, a request was made, whether it was watch-listed or red-flagged, and the international police were able to locate him, and they were satisfied that a proper order for his arrest and return had been submitted to them. I do not believe that once that person is back in the Nigerian territory, our government has to answer for whatever was improperly done by other sovereignties and countries that assisted the SSS. But I don't think that from all that we know in this case, unlike somebody who has not been facing any trial at all, that's where the issue of extraordinary rendition becomes operative. What does it mean? That is where a state seeks to transfer a criminal suspect to a jurisdiction that does not guarantee the person's fundamental rights, such that if they had gone through the judicial process, that request will have been refused. In this case, Mr. Kanu was undergoing trial in a properly constituted court of law. He has pleaded to the charge, is prepared to face his defense, then he eloped, he fled the country. That cannot bring in issue of extraordinary rendition. It probably will have happened if they were to have ferreted him from UK to Nigeria, because in that case, he'll have to undergo extradition procedure. In this case, he was found, from all that we know, in a third-party country, and there was a request to Interpol where he was arrested, and then through interagency cooperation, he found his way back to Nigeria. That is not a case of extraordinary rendition, because extraordinary rendition itself constitutes one of the international crimes against humanity now. The reason America has been able to get away with it severally is because they are not signatory to ICC convention, the Rome Convention. So they are not bound by it. But if Nigeria was, for any reason, to have been found to have violated that law in the manner in which Mr. Kanu was brought back to Nigeria, some people in Nigerian government, as you know, will have to answer for that at the right time. But I don't think that's what has happened in this case. We must be careful not to confuse some of these concepts.
All right. Senator Baribe keeps on saying, respect the rights of Nnamdi Kanu. Let's even know what are his rights now as we speak with all of this brouhaha leading up to the 27th of July. Yes. Now, once Mr. Kanu gets into Nigeria as a suspect standing trial, the right he has is to be brought, because once you jump bail, the court issues bench warrant for your arrest. Now, that bench warrant, once it's executed, the proper thing under the rule of law is to take that suspect back to the court that granted the bail and issue the bench warrant. I think in this case it has been done. Now, having been done, it is natural, even if he did not leave Nigeria, if he just failed to appear in court for one day for no reason, it is within the power of the court that granted the original bail to revoke that bail. But it does not preclude Mr. Kanu to apply as many times as he can for reconsideration of his bail condition. He can always reapply to the court for a bail to be granted. It's not like other cases where once the court makes another one, let's go on appeal. In a matter of bail, the court is empowered to always reconsider your application when circumstances change. For instance, if Mr. Kanu suddenly develops some health challenges that cannot be handled in the correctional facility where he is presently being held, it will be a good basis to apply to the same court to reconsider his application and probably grant him bail, maybe on more stringent terms than was initially imposed on him when he first was granted bail. So far as the procedure followed by government after Mr. Kanu entered Nigeria is concerned, I think it's covered by the Arbitration of Criminal Justice Act, which is what now regulates criminal proceedings in the Federal High Court where Mr. Kanu is standing trial. The court did the right thing by taking custody of him upon his return and then order his remand. It does not mean that Mr. Kanu must wait till 27th of July before he can apply to the court for bail. He can, in the meantime, apply for bail if there are
pressing circumstances and urgent consideration that will sway the court to consider his bail application. But don't forget, the trial was a part-hard matter, so trial just will continue from where it stopped. The only worry is, I don't know how much longer the presiding judge still has to sit, because a number of our judges at the Federal High Court are going to be retiring very soon. So the chances that at the time that has been lost since 2017 and now might have affected the opportunity for the trial to be concluded, so that Mr. Kanu will know his fate. In any event, under the ACJA, where trial is delayed for whatever reason beyond 1 year, it's a good reason why an applicant for bail should be favorably considered. And this is a trial that has been delayed for since 2017 till now, except that the delay was not by the state. It was so far by the act of the suspect defendant himself.
Well, you stated the technical details of the law, the way it should be in an ideal situation. But given the political side to this Nnamdi Kanu trial, will it be a wise thing? Do you think the court will consider it wise? A man who has been a fugitive from the law, a man who obviously could still be a flight risk, to grant him any application for bail. If you were to advise the prosecution, what advice will you give the prosecution?
Well, the prosecution will have to react to application for bail based on the information at their disposal. And if they consider, like was decided in the case of Asari Dokubo and Federal Republic of Nigeria, the fundamental reason for granting bail is so that the accused can give assurance that it will be available to stand his trial. The act of jumping bail already defeats that presumption in his favor. But beyond that is that in between the time of Mr. Kanu jumping bail and now, a number of things have happened, which the court also is allowed to take into consideration when an application for reconsideration of bail is brought. There have been a lot of things in the media, in the social media, most of which we cannot verify where they are actually attributed correctly to Mr. Kanu. But if indeed they are, they constitute serious matters of consideration about threat to the security of the country and peace of the country in determining whether if Mr. Kanu were to be granted bail afresh, the state and even the populace will not be at peril. I'm sure you know that just like Mr. Kanu, Mr. Showore was granted bail, and when he was granted bail, he was limited to stay within Nigeria. In fact, I think stay within Abuja, if I'm not mistaken. So maybe those are the things that will come into play. But I do not see that the government, having been put through the expense of taking this circuitous route to get Mr. Kanu back to the country, will willingly concede to a bail application pending trial at this stage.
All right. So there's a story.
It just appear like they have walked with their hand and used their leg to scatter the reward of it.
Okay, so there's a story these days saying the federal government is looking at mass murder charge. I mean, can you take us through the thinking of that they are setting up a team of lawyers to be able to look at it as part of the allegations they're bringing forward against Nnamdi Kanu? Can you make sense of it for all of us? And also, the angle, a lot of people are asking, how did he get a passport to travel? They're citing Britain in all of this, because if his passports were deposited at the court prior to this time, his Nigerian and British passport, so how did he move around? I mean, that's another part to it. So there's an international dimension to it. Can you talk us through those factors in all of this?
Yeah, on the first one, in fact, one of the conditions on which a person standing trial who has had his bail revoked may be refused application for bail is if in the interval there are other offenses that are just as serious. In fact, one of the conditions for bail is that you are not likely to commit another offense during the period that you are on bail. If the state now believes that certain things have happened that constitute even more grievous offenses, he has to be charged with that separately. But the information about that being in the offing might be brought to the attention of the present presiding judge over the case that's going on. Not necessarily to prejudge the mind of the court, but because the law makes it an exception, that is one of the things that the court can look at. When the issue of security is concerned, the court can always look at that. It's not going to have effect on his impression about his status about the case he's standing trial over. That's number one. So, but whether it is politic, whether it is desirable, whether it's defensible and fair to charge Mr. Kanu with murder or whatever as a result of his agitation, and then leave a lot of other people who are causing the same kind of or worse atrocities in other parts of the country at this stage is a political judgment for the state to decide. But I would rather that the state looks at it dispassionately and project the impression that they are even-handed in how the law is being enforced. There's nobody you are going to convince, if you are from the southeast or from the south, that what is happening to Mr. Kanu, as against what others are doing in other parts of the country, is not some kind of scapegoating. But that's not to say that Mr. Kanu should not answer for his offense. What we are saying is that others who are similarly positioned, constitute the same kind of threat, should also be seen to be facing their music. Because this is a way in which this kind of thing gives the impression that others can enjoy impunity. Why, unless you are from a part of the country, that's when you should be afraid that you are going to face the wrath of the law. I think government should look at that critically. If we want the public to believe that the law actually is taking its course and rule of law is being even-handedly applied, then that's for that. Now, I think you also asked a second question.
Yes,
can you remind me about that?
Talked about Britain in all of this. You know, since his passports were deposited in the court before.
Yes, now, exactly. About how. Yes, you also asked about how Mr. Kanu was able to leave the country when he deposited his passport. Now, yes. Now, I'm not sure because a passport is property of the issuing state. A British passport is issued in the name of Her Majesty the Queen. A Nigerian court cannot order a Briton to submit his British passport ordinarily without creating a diplomatic problem. You may refuse to grant the person bail, but you cannot ask him to deposit his international passport that is not issued by Nigerian government, which is not Nigerian property. It's also not the person's property. It's a permit, but the property in the passport is in the name of the sovereign of the country that issued it. So what I suspect must have happened is that Mr. Kanu, having deposited his Nigerian passport, which Nigerian government can actually impound, they cannot, if he's granted bail, unless the order of bail restricts him from traveling, they cannot restrict him from traveling across Nigerian border. So he must, I suspect, have traveled using his British passport. And that probably explains why, in the situation that we have found ourselves, the British have interest in how Mr. Kanu was brought back to Nigeria. So it's probably one of the things that Nigerian courts will have to consider, especially when somebody has a dual citizenship and is undergoing trial for a serious criminal offense. It may not suffice to ask the person to deposit his Nigerian passport. The court can ask him to deposit all his traveling documents without necessarily mentioning passports. So that way, they can have a cover if it becomes a diplomatic issue that he cannot leave Nigeria, so he must submit all his traveling documents, including Nigerian passport. So traveling document will also, of course, include his international passport.
Let's do Owonikoko question. We're almost running out of time. But very quickly, if you can respond to this in 30 seconds. The point you made about impunity and the people seeing that justice is done, is it part of the responsibility of the courts to worry about the political environment of a case before it, or to just focus on the technical details of the evidence advanced before the court?
Well, it's public policy is part of what the courts take into account, and political climate and tempo. While the court would not expressly express it in the letters of their judgment, it forms part of what they take into account when they are looking at a matter. So, because at the end of it all, everything is politics. Even law itself is politics. Implementation of law is politics. So, a very experienced judge will not just apply the law mechanically. He will apply the law with flexibility and some form of political circumspection, so that when all other people are getting away with this kind of thing, based on supposedly where they come from in the country, the court will also want to be very careful not to appear to be slamming the hammer just because a particular defendant has become an enemy of the government in power, not the state. There's a difference between the government in power and the state.
Yes,
and offenses are normally prosecuted against the state not for the purpose of a government in power.
Thank you.
That is the problem people are seeing now.
Thank you very much.
The offenses being prosecuted are only prosecuted when they are against the government in power.
Thank you very much, Owonikoko SAN. Always a delight to have a conversation with you. Thank you very much indeed.